What are intercompany agreements? Intercompany agreement, often referred to as ICAs, are legal agreements between related parties, such as companies within a multinational group. They define the terms of intragroup transactions, such as those relating to goods, services, intellectual property, and loans. Why do multinational groups need them? ICAs are an essential part of transfer pricing documentation. Tax authorities expect to see them, and if agreements are missing or are defective, then tax authorities will form their own conclusions as to the nature of the intercompany transactions, which may expose the group to unnecessary tax audits, fines, and penalties. What would make an intercompany agreement defective? ICAs must match the group's transfer pricing policies, its actual business operations, and the way that it uses intellectual property, assets, and finance. When do MNEs need to have ICAs in place? ICAs should be created and signed before the start of the group's financial year. Among other reasons, the OECD's transfer pricing guidelines make it clear that retrospective allocation of risk does not work. Are intercompany agreements real agreements? Yes, absolutely. They are not just for tax. Intercompany agreements are fully legally binding contracts, and their terms can make a significant difference to the outcomes for creditors in corporate insolvency procedures. Why do some multinational groups find that their intercompany agreements are defective, even when those groups have sophisticated tax and legal functions? This is often due to a skills gap. Tax professionals are often unfamiliar with the drafting of commercial contracts, and commercial lawyers are often unfamiliar with the principles of transfer pricing and OECD guidelines. The following case study and link to LCN Legal's document automation platform will allow you to create an OECD-compliant and legally effective intercompany agreement in just a few minutes.